Welcome, class. We're continuing our discussion in POS 475, Constitutional Law, on the death penalty. And Natalie.
Yes.
Based on our previous class discussion, in Furman versus Georgia, 1972, why was the death penalty considered unconstitutional at the time?
Because it was being enforced unfairly and sporadically.
Yes, it was being arbitrarily and capriciously applied in a wanton and freakish manner akin to being struck by lightning. Right? So, were there racial disparities in sentencing? Were black men more likely to get the death penalty than white men?
Yes.
Yes. Right? And so that was one of the huge concerns that the court had with the death penalty at the time. And that is why they declared it cruel and unusual punishment. Because one person was getting off with a very light sentence, one person was getting the death penalty, and they both had committed very similar crimes, right? Now, were there some members of the court who thought that the death penalty was inherently cruel and unusual punishment,
Yes.
even if it was being consistently applied?
Yes.
Yes. Yep, like Brennan and Marshall, classics. But other members of the court said, if you can make the sentencing more consistent, more predictable, more fair, then the death penalty is still constitutional, right? But you need to change your state laws to make it more consistently applied, right? So Georgia did that. They developed the bifurcated trial, right? Where they had the trial first to determine guilt or innocence. And then if the person was found guilty, then they had a separate sentencing portion. And during the sentencing, the defense presented mitigating factors, and they were allowed to present any mitigating factors they thought were reasonable. And prosecutors presented aggravating factors. And at least one codified aggravating factor needed to be present in order for someone to receive the death penalty, such as killing a judicial officer for practicing their job, for doing their job, right? Or wanton, vile, or vicious murders, chopping people up and putting them in the fridge, right? That type of thing. And also the Georgia Supreme Court reviewed all death penalty sentences, right? So in Gregg versus Georgia, did the Supreme Court rule that Georgia's law was constitutional and the death penalty was a viable option?
Yes.
Yes, very good. All right. And so that's basically where we ended. And keep in mind, there are still some members of the court that think the death penalty is inherently cruel and unusual punishment, no matter if it's applied consistently or not. And there's others who say the American people appear to like it. It is in harmony with their values. It was not considered cruel and unusual punishment at the time of the founding. So it's on the table if a state wants it to be on the table. Make sense?
Mm-hmm.
Okay, so that's where we are. Well, then a study came out looking at the death penalty, and they tried to determine whether it was being consistently applied or not. And it was called the Baldus study, right? And this allows me to combine two of my favorite subjects, constitutional law and methods. So, in the Baldus study, they asked, did a person receive the death penalty or not? right? So death penalty is on your y-axis, right? What kind of variable do we have here, Michael?
Dichotomous.
A dichotomous dependent variable. So what statistical approach is, or are the researchers going to use?
Logit or probe it.
Logit or probe it, absolutely, right? See, so we actually understand the dependent variable, what statistical model the researchers used, right? And they looked at the influence of a lot of independent variables on the dependent variable. So, Natalie included, what do you think makes a person more likely to receive the death penalty?
The crime they committed, past
Okay.
actions.
Oh, right. So, previous record. You know, how about number of previous offenses? That's a nice one.
How nasty the crime was.
Yeah.
Severity of
I don't
offense.
know how you measure disgusting, but don't they usually kill or do the death penalty if it was like really?
Yeah, it's got to be murder. Yeah. But some murders are worse than others,
I mean,
right?
Silence of the Lambs type stuff. Like,
Yeah,
that's really
exactly.
weird.
Okay. These are all good independent variables. How about the wealth of the person who committed the murder?
Yeah.
Yeah.
Yeah, okay. Wealth of defendant. Very good. Wealth of defendant. How about the quality of their representation?
Yeah.
Yep, and that is probably affected by the wealth of the defendant, but sometimes wealthy defendants hire poor representation, like Larry Langford, which we discussed. Quality of representation. Okay, I don't know all the others they had on here, but according to the textbook, they had 230.
Oh my goodness.
230 independent variables. Right? Okay, so those look like good ones. I like number of previous offenses. So let's just look at that one. Number of previous offenses. The more previous offenses you have, what do you think happens to the probability you will receive the death penalty? Increases. Right. So Michael, since you took me for methods, what will that relationship look like? Linear, or will that be an S-curve?
S-curve.
Probably an S-curve. Exactly. Right. So, if you have committed, we'll do this low to high. If you have committed a lot of previous offenses, it probably increases the probability that you will receive the death penalty, right? Okay. Now, 230 variables, one of which was race of the defendant, right? And particularly, they were looking at African Americans, right? So, race. So, what do you think happens to the probability that you will receive the death penalty if you are African American?
I'd say it increases.
It increases. Absolutely. Right? How many times do you think?
Like 0.2. Like
Double, triple,
nah, just like
quadruple.
I'd say like 20%.
20%? Interesting. Okay. It actually, according to the Baldus study, black defendants were 1.1 times more likely than other defendants to receive death sentences. 1.1. 1.1 times.
So 110%
No, 1.1 times.
Oh.
So let's figure out the numbers, right? So it's statistically significant, but this is why I asked Michael to come in. He's taken me for methods. This is my own paper here I have here. They looked at 2,484 Georgia murder cases from 1973 to 1979. Right? So it was longitudinal data gathered over a number of years. 2,484. Is that a large data set?
Yeah.
Yeah, that's a large data set. Okay, now let's just talk statistics a minute. I know there's constitutional law, but let's just talk statistics a minute, right? If I have 20 independent variables, right? What's the problem? How many of them are probably going to come back statistically significant at the 0.05 level, even if there's no relationship between any of those independent variables and the dependent variable? 1. Why?
That's just laws of probability.
Laws of probability. Exactly. That's what 0.05 means.
Yeah.
Right? So if I have 100 variables, how many are probably going to come back statistically significant? 5. If I have 200, how many are going to come back statistically significant? 10. So if I have a data set that has 230 variables, will some come back statistically significant even if there's no relationship between every variable and the dependent variable?
Yeah, almost definitely.
Yeah, almost definitely. Yeah, it's just the way it works, right? It's the laws of probability,
Yeah.
right? So, all right, so that's concern number 1, right? Next concern, 2,484 Georgia murder cases. So I'll just write that down. 2,484. And how many people receive the death penalty? 128. Okay. So 128 out of 2,484 receive the death penalty in Georgia murder cases, right? Just eyeballing that, Michael. Give me a very rough percentage of defendants that receive the death penalty.
It's like 5%.
It's around 5%. Outstanding. That's why I invited Michael in for lecture today. He's good at math. 5%. So are you, Nat, but, So, that's about 5%. So, what is 1.1 times 5%?
Oh, just, what should I call it? 5.5.
5.5.
Yeah.
So...
That's like nothing.
Yeah. you gotta be careful saying those things, right? So, the chance of receiving the death penalty overall is 5%. The chance of receiving the death penalty for black defendants is 5.5%. Okay, now, is that a statistically significant difference when I have a sample size of 2,484?
Yes.
It is. So, once we've determined statistical significance, what do you need to determine? Substantive significance.
Yeah.
And substantive significance is tricky.
Yeah.
Right? Because now you're left with, blacks are more likely to receive the death penalty, but how much more likely?
Yeah, why are we talking about, 3 or 5 more?
Well, right, 1 out of 200.
Yeah.
right? And that means, and they only had 128 receive the death penalty over 1973 to 1979.
And how many of those were black?
Right. How many of the 128?
Yeah.
Right. So, this is the evidence they brought, right?
Okay.
But the thing is, I don't know if anyone did the math for the court. You know what I mean? It requires a certain understanding of statistics, probability, the likelihood of finding statistical significance. You know, if someone says, oh, they're 1.1 times more likely to receive the death penalty, like, well, what does that mean? Numbers-wise, what does that mean? It means the difference between 5% to 5.5%, right? Okay, so you got the numbers? All right. So the case went to the Supreme Court. In the case of McCleskey versus Kemp. And that's where they really relied on the Baldus study. So McCleskey was a black man, and 3 accomplices attempted to rob a furniture store in Atlanta, Georgia. A police officer responds to a silent alarm and is shot and killed. Okay, so police officer killed while in the line of duty. How's the jury going to respond to that?
Death penalty.
Well, yeah, exactly. So several weeks later, when police arrested McCleskey on another charge, he confessed to the robbery. At trial, an accomplice identified McCleskey as the shooter. Prosecution also entered evidence that McCleskey bragged about the shooting.
Ooh.
Oh, no.
Yeah,
That's
juries.
the worst
Well,
thing you could do.
juries don't like that, right? So McCleskey was convicted and sentenced to death. Case went to the Supreme Court, and that's when the Baldus study was presented, and his defense attorneys tried to say there are still these racial disparities in sentencing. But the court looked at the evidence. They looked at all the data. Are members of the Supreme Court pretty bright?
Yeah, I think so.
Yes, actually they are. They can have these things explained to them and they can understand it. And so they upheld his conviction. And they said, even though there are statistical disparities in sentencing, that does not prove that there was prejudice or bias in this particular case, right? And so they said McCleskey had offered no evidence specific to his own case that would support an inference that racial considerations played a part in his sentence. So even though there may be statistical disparities, if it looks like your own trial was free of prejudice, then you can't try to make the claim that you've been a victim of racial bias. What do you guys think of that ruling?
Makes sense.
It does make sense. Again, as I mentioned, if receiving a death penalty is your dependent variable, and you have 230 variables, are some of them going to come back statistically significant?
Yeah.
Yes, right? So one thing is that's just statistics. Another point is, do the wealthy get better representation? Probably. Are the wealthy less likely to receive the death penalty? Probably. Yeah. But that's another way of saying the criminal justice system isn't perfect.
Yeah.
Right? And statistically, you're never going to get a perfect criminal justice system.
Yeah.
Not when you have human beings that are jurors, judges, prosecutors, defendants. It's run by human beings, and are human beings fallible?
Yes.
Yes. Do they have biases?
Yes.
Yes, absolutely. And so the court said, you're not going to have a perfect criminal justice system, but we don't have the racial disparities in sentencing like we used to. The death penalty is not being applied in a wanton and freakish manner akin to being struck by lightning like it used to be. And so no criminal justice system is perfect, but we'll continue on with what we have. Make sense?
Yeah.
All right. Michael, now that we're done with the baldest study, you can leave. You can keep this for your own records if you want to.
Thank you.
Yeah. All right. And so that was McCleskey versus Kemp, 1987, right? So Nat, tell me, do you have any concerns after McCleskey versus Kemp? I don't know. I'd like to see, again, the influence of wealth a little more on the probability that you'll receive the death penalty.
Yeah.
Yeah. The next thing, now that Michael's gone and we can just talk about this, sometimes people kind of get trapped in their own worldviews and they have a problem maybe seeing things from a different perspective. If you're trying to make the argument that the death penalty is being, that there are disparities in sentencing when it comes to the death penalty, rather than race, what's an obvious characteristic where there are definite disparities in sentencing? Gender. Very good. How'd you know that?
Because I've watched a lot of Murder, She Wrote.
Okay.
And if you notice, it's like the women are always like, it was self-defense. They usually get off work. That's just what I'm saying from all the... I watched a lot of Murder, She Wrote.
Okay, very good. So gender's the one staring you in the face. So what percentage of the people who receive the death penalty are men?
Probably a lot more, to be honest.
Take a guess.
60. 70. 80. 90. 100.
98 to 99. 98 to 99% of all people who receive the death penalty are men. Right?
That's not good, y'all.
Well, okay, so if you're trying to make the argument that there are still disparities in sentencing, and that's your argument, then what's your best evidence? Racial disparities in sentencing or sexual disparities in sentencing?
Sexual disparities.
Sexual disparities, absolutely. So why didn't the defense make that argument?
I have no idea.
I have no idea either. Right? And again, this gets kind of back to the idea of we have a criminal justice system and it's not perfect. And sometimes people have blind spots and they don't see things. Right? And again, well, and also, again, it doesn't fit the narrative, right? Have women overall been disadvantaged in many ways in our society?
Yes.
Yes. You want to know one of the areas where they are definitely not disadvantaged?
Crimes.
The likelihood that they will receive the death penalty. Absolutely, right? Now, then you could say, oh, but men commit more crimes or more murders than women. And, okay, that's fair enough, but then why is that? What type of a society have we created where men commit way more crimes than women? See, that doesn't get you off the hook. Oh, well, men commit more murders. Well, they grow up in our country. What have we done in our country to turn men into murderers?
I do not know.
Well, I don't know either. Is it encourage them to play football? Encourage them to be more violent? Encourage them to join the military? Encourage them, reward violent conduct in countless number of ways? I don't know, right? But the fact is, last data I saw, men commit about 90% of the murders. And they constitute about 98-99% of those that get executed. So, number one huge broad concern, why are men so more likely to commit murder? Is it the way our education system is run? Is it? I mean, I'm dead serious when I ask this. That you look at the special education classes, and typically males are overrepresented in special education classes. School in many ways is designed in ways that girls thrive, whereas as boys not so much, right? Yeah. Anyway, we don't. The point is, you have to ask yourself that question, right? What do we as a society do? What kind of society have we created? What kind of education system have we created? What type of recreational opportunities available? Whatever. That men wind up committing 90% of the murders. And they wind up receiving the death penalty at higher rates than women. Right? Fair questions. That's one of the reasons why I prefer gender studies rather than like feminist studies. Because I think, yes, women historically have been disadvantaged, and historically they've have not received nearly the opportunities men have had, that type of thing. But at the same time, there are situations where men definitely are disadvantaged. And receiving the death penalty is one of them. Okay. That takes us to Atkins versus Virginia, 2002. Okay, what happened in Atkins versus Virginia? My daughter is here, Natalie. She's helping participate. She's doing a great job, but she has not read all of these. I know. And so usually in class I say, what are the facts of the case? And students give me the facts of the case, and we build on that. And then I'm having to give all the facts of the case. So hopefully I'm not burning you out on that. But basically in Atkins versus Virginia, what happened was Atkins and another man, they'd been substance abusing all day, right? Drinking and smoking, and I don't know, I think there may have been some marijuana involved. The type of thing is, nothing good was happening all day long, right? Then they went out and they took an airman in the military, took him to an ATM at gunpoint and forced him to withdraw money, right? Then they took him into the woods type of a thing and shot him, right? Now, does that suggest a fairly well thought out plan?
No.
No? You don't think so?
No.
No?
I haven't watched it.
Okay, well, yeah. We're not holding this to the standard of Murder, She Wrote. I'm just saying, does it sound like they knew what they were doing?
Okay, sure.
Okay, yeah. All right, there you go. So anyway, at trial, the defense presented evidence that Atkins had a low IQ, right? Okay. And so the question came up, is it cruel and unusual punishment to execute the mentally retarded? Right? And I'm not being politically incorrect there. Those are the terms the court uses back in 2002. The case went to the Supreme Court. And the Supreme Court said it is cruel and unusual punishment to execute the mentally retarded or the mentally challenged. It said mentally retarded in the opinion, so that's what we'll use. So, now, again, Natalie, you haven't been with us the whole semester, so you don't know these things. But Kennedy wrote the opinion. And remember, Kennedy spent his summers in Austria. Yes, in Austria, where he attended international law conferences and that type of thing. And when it comes to the death penalty, are we an international anomaly? Are we different from other Western industrialized countries,
Yes.
democracies? Yes, we are. And so, even though we allow the death penalty in general, this case limits when the death penalty can be applied. It can't be applied in situations where the defendant is deemed mentally deficient, right? So tell me, Natalie, how are you going to determine whether a defendant is mentally deficient or not?
Well, there's IQ.
There is IQ.
But then there's also personality. And, okay, bear with me. Sometimes...
Speak loudly, though.
Okay. Even if a person has a higher IQ, sometimes they're not all there socially. Does that make sense?
Sure.
Yeah.
So they can solve puzzles and identify patterns and remember things well, but have other mental problems.
Yes.
Yes. Yeah. See, those three things I mentioned earlier, they're classics on IQ tests, right? Patterns, memory, that type of thing. Anyway, so I have a question for you. If I'm a defendant, what incentive do I have to score well on an IQ test?
I don't really know.
No, why would I? If I'm trying to make the argument that I'm mentally deficient.
Oh, you wouldn't. It'd be circle.
Don't know that one. Don't know
Circle, triangle, circle, square.
Right. Yeah, exactly. So, in a situation like this, Natalie, where the defense is making a claim that they are mentally deficient, who will make the determination whether they are mentally deficient or not? A jury or a psychologist?
Well, in this case, it'd be a jury, but it should be a psychologist.
Well, see, that's the thing. After this court case, that is who determines whether you're mentally deficient or not, is a psychologist, right? And that is why, what do you think Scalia did agreed with the majority opinion, or dissented?
Oh, he dissented.
He dissented, of
Always.
course. Always, right?
He likes to write them.
Well, he has a very consistent approach to the Constitution, right?
Yes.
And are you guaranteed a trial by a jury of your peers?
Yes.
Yes. So he said, in our country, under our Constitution, guess who decides whether you knew what you were doing or not?
The jury.
The jury, not some psychologist that gives you an IQ test, right? Scalia then said the culpability, the blame ability, if that's not a word, but I'm just trying to, how culpable you are means, how capable of blame you are. How responsible are you, right? So he said basically the culpability of the defendant should be determined by the jury, not a psychologist. And he said the jury specifically looked at all the evidence, and whether or not the defendant knew what he was doing was central to the prosecution's argument. They said he definitely knew what he was doing. That's why they kidnapped this guy, had him go to an ATM at gunpoint, forced him to withdraw the money, and took him into the woods, right? And shot him. Was because they knew what they were doing. They didn't just say scram or run off once they'd gotten their money. They took him into the woods and committed cold-blooded murder. And so Scalia said, I can't agree with this opinion. Basically, we have protections in our country. One of them is a jury trial, and they're the ones who decide whether or not you knew what you were doing, not some psychologist, right? So, in typical Scalia fashion, if you want the mentally deficient to not be eligible for the death penalty, what should you do?
Make an amendment.
Pass a constitutional amendment. That's right. Persuade your fellow citizens that there are some people who are so mentally deficient that they shouldn't receive the death penalty. And you can go over how that's determined and all kinds of stuff. Okay. Now, the defense tried to make an interesting argument in Atkins versus Virginia, and that was that the mentally deficient are particularly vulnerable and less likely to receive a capable defense because they're mentally deficient. So, say I'm mentally deficient and I'm working with my defense attorney.
Yes.
Right? I may have certain information that could be used to help exonerate me, free me from guilt. But if I'm mentally deficient, do I know that it's important to share that with you?
No, you do not.
Not necessarily, right? When my defense attorney asks me certain questions, is there a possibility that I will not understand them fully?
Yes.
Yes. Right? And so you can go through other questions like this, and the point of them all is, for all these reasons, the defense is less likely to the mentally deficient are less likely to receive an adequate defense. And so we need to be particularly careful in these situations. And they shouldn't be eligible for a death penalty because they probably didn't receive an adequate defense. What do you think of that argument?
Makes sense.
Makes sense a little bit. Scalia didn't like that argument.
Of course.
right? Of course, Scalia didn't like it. When you see someone who is mentally deficient, is it human nature to be more sympathetic toward that person, or not be as sympathetic?
Be sympathetic.
That's Scalia's argument, right? Are the mentally deficient in many ways childlike?
Yes.
That was Scalia's argument. And so he said, that's why we leave these things to a jury, right? They're probably going to be more sympathetic in this situation. Mentally deficient defendants come off as more childlike. And so leave it to a jury to decide how culpable they are. All right. Now, any questions on that?
No.
No. All right. Now that takes us to a couple other cases. These are very, very quick. In Roper versus Simmons, 2005, the court determined you can't execute minors. Why do you think it's cruel and unusual punishment to execute a minor?
Their brain isn't fully developed yet.
Yeah, that's part of the argument, right? And is that just opinion, or is that a scientific fact?
Scientific fact.
Yeah, it's kind of one of those things where, we've decided, 18 is the age of majority, and that's when you're a legal adult, you can vote and do all kinds of things. But as we see in the state of Alabama, what's the age of majority?
I don't know.
Oh, you don't know?
No.
It's 19.
Oh.
Yeah. You can't enter into a contract until you're 19 in Alabama. Why do you suppose we made it 19 in Alabama? Because we realized your brains aren't fully developed, right?
They're not fully developed until you're like 20-something.
Yeah, I mean, it's a while. So, in Alabama, you can't enter into a contract until you're 19.
So I couldn't buy a house when I was 18.
Mm-mm. We tried to set up a bank account for Michael, and he can't be the only person. We'd have to co-sign for him to open a checking account. Yeah, and he's 18 now.
Yeah.
Yeah, and so, he can go to college. He, there's a lot of things we'll let you do, but can't enter into a contract, can't open a bank account on your own. I think there's something, I don't know about firearm purchases. I'm not a big gun nut guy, but Brother Binkard can tell you about that. He runs a pawn shop.
Yeah, I'll ask him.
Yeah. But anyway, again, with Roper versus Simmons, 2005, you can't execute minors. Think Scalia's going to agree with that or dissent?
Did he dissent on that?
Yeah.
Of course.
Yeah. It's very predictable after a while, right? What are you guaranteed?
Right to trial by jury.
Trial by jury. Are you allowed to be confronted with the witnesses against you?
Yes.
Yes. Do you have the right to counsel?
Yes.
Yes. Are you entitled to a speedy trial?
Yes.
Yes. There's all kinds of protections, right? And he said, yeah. So, anyway. Next, Coker versus Georgia. You can't execute a person who raped an adult. Then Kennedy versus Louisiana. You can't execute child rapists. So, what's happening to the number of people that can be executed?
It is going down.
It's going down, right, exactly. Well, based on their individual characteristics, how old they are, if they're mentally deficient, that types of things, or those types of things, and also based on the crimes they committed. right? Now, if we were in class, I'd probably get a reaction out of some of my female students on you can't execute rapists. They usually feel really strongly about this, and it's interesting. So, we live in democracy, people have different views, but the court said you can't execute a person who raped an adult, and you can't execute child rapists. So, all right, now that takes us to Ewing versus California, 2003. Before we talk about Ewing versus California, let's just talk about a general principle. And that is whether it is cruel and unusual punishment if you receive a sentence that is grossly disproportionate to the offense that you committed, right? So let's say I write a bad check, right? $20 check, and there were insufficient funds, and the check bounced, and that type of thing. So basically I stole because I wrote a bad check. Do you think I should go to jail for 20 years for that?
No.
Why not?
Because it wasn't that big of a deal.
Okay, exactly. The penalty is grossly disproportionate to the offense, right? So the court, over the years, has looked at a number of cases dealing with, like, writing bad checks and that type of thing. And when people received really severe penalties for rather minor infractions, the court said that's an Eighth Amendment violation because the penalty is grossly disproportionate to the offense, right? Okay, so that takes us to, with that background, that takes us to Ewing versus California, 2003. Now, California has the initiative process, right? What does the initiative process mean?
I do not know.
You don't? Okay. The initiative process means that people are allowed to circulate a petition, get a required number of signatures, and if they get the necessary number of signatures, then the people vote directly on that proposition in the next election. So the people are allowed to pass their own laws.
Oh, I like that.
Well, yeah, a lot of people like that because it allows the people to get involved in the legislative process. You're not just dependent on the state legislature. The thing with the people, though, is are Americans amazingly punitive?
Yeah.
Yes, right? Other than minor traffic violations, are Americans basically pretty law-abiding citizens?
Yeah.
You know, we are. Overall, as a society, basically pretty law-abiding. People really support things like 3 strikes and you're out legislation, right? The idea that if you commit 3 felonies, then on your 3rd felony, we're locking you up for a long time and throwing away the key type of a thing.
Uh-oh.
Right, exactly. So, Ewing had 2 previous felonies, and then on his 3rd felony, he was trying to steal 4 golf clubs, or did I say 4? I'm sorry, 3. He was trying to steal 3 golf clubs worth $400 each. Yeah, so it's $1,200. And he walked out. He put him down his pant leg. I know. And he walked out with really a stiff leg and was caught and was arrested. And then it went to the prosecutor. And his case, what was called a wobbler. And it could be charged as either a felony or a misdemeanor. And the prosecutor chose to prosecute him as a felony. And he already had 2 previous felonies. So the case went to the Supreme Court, and they were asked to declare this cruel and unusual punishment because it was grossly disproportionate to the offense. Because it was his 3rd strike, he received 25 years.
Dang.
Yeah, 25 years. So case went to the Supreme Court, and the Supreme Court upheld the 3 strikes and you're out legislation, right? And they said it wasn't just for stealing 3 golf clubs that he got the 25 years. It was the totality of the offenses that he committed. So they said basically if the people of California have determined that they like this policy, we're not going to overturn it. Is it pretty strict? Yeah, it's pretty strict, but it's not grossly disproportionate to the offense. His previous offenses were pretty severe. They're like one was like kidnapping.
Oh.
Yeah, I think, yeah. And so the majority in Ewing versus California said it's not that we're throwing a golf club thief in jail for 25 years, right? That's the way the defense was portraying it. You're throwing in a golf club thief for 25 years. So no, it's everything. That's why he's going in for the 25 years. What do you think about that ruling?
Well, we kind of know one of his other crimes, but I don't know the other one, so.
Yeah, it was pretty bad too.
Oh, okay.
I believe,
well, then
yeah.
I kind of agree with it.
Yeah. And that's where it is, so Ewing's out of luck. And the point is, the court is willing to uphold some pretty severe sentences. We've seen that with the war on drugs. You get thrown in jail for a long time for having a little bit of crack cocaine. And there. So, anyway, that's where we end. So, we ended with the death penalty cases here. Has the court limited who can receive the death penalty and for what crimes?
Yes, they have.
Yes, they have. So, okay. Well, take care, class. Hope you guys are doing well. Bye-bye.